consequent effect on our individual and collective privacy has to be acknowledged and addressed. There's a tendency for persons to hide behind the perceived anonymity that comes from using a username and/or a user profile while sitting behind a computer screen or when using a handheld device to engage in offensive, hurtful, divisive, and destructive discourse. These persons may feel that they are empowered, but their actions can infringe upon the rights of others, with the aggrieved persons having no recourse, unquote. Paragraph 36 of the judgment. In respect of online conversations, he observed as follows. The impact upon an individual's privacy is tremendous, and the absence of clear and cohesive legislation to protect our citizens' privacy and to punish those who violate the rights of others can cause us to descend into a bottomless pit of anarchy. The time for legislative intervention is long overdue, unquote. In its editorial of the 6th of April, 2024, the Sunday Sun wrote inter alia, truth be told, some regulation is needed in Barbados, if only to, 1, protect our children from those who will wish to do them harm through sex, manipulation, and violence. 2, hold people accountable for what they say about others. 3, shield consumers from unscrupulous business practices. 4, protect our constitutional rights to privacy and the maintenance of people's good name. The internet is invaluable, but it does not provide an avenue to shout fire in a crowded place when there is no just cause. Sir, the Computer Misuse Act that is presently part of the Statute Law of Barbados, Cap 124B, was enacted in 2005. That's about 18 years ago, roughly 19. I think it is accepted on all sides, including persons who have held themselves out to be experts in this area, that this act, the Computer Misuse Act, is outdated because the march of technology and the variety of computer systems have made it antiquated. Secondly, it is far too narrow in its scope to be an effective tool for the police and prosecutors to cope with contemporary criminals and the variety of cyber crimes that have been spawned since 2005. And thirdly, as was acknowledged by one of the critics of this bill, at first, prior to the Minister Carroll speaking, the existing legislation itself is in need of substantial revision or repeal. For example, Section 14 of the bill, which deals with malicious communications, merely provides, and this is all it says, quote, where a person uses a computer to send a message, letter, electronic communication, or article of any description that is A, indecent or obscene, B, is or constitutes a threat, or C, is menacing in character, and he intends to cause or is reckless as to whether he causes annoyance, inconvenience, distress, or anxiety to the recipient or to any other person to whom he intends it or its contents to be communicated, is guilty of an offense and is liable on summary conviction to a fine of $10,000 or imprisonment for 12 months or both. The Cybercrime Bill 2024 that is engaging the attention of this esteemed committee is not Barbados' legislative response to the plea of Mr. Justice C. Prasad. On the other hand, it is really, this bill is really the legal measure adopted by the government of Barbados to establish certain criminal offenses under our domestic law, but using the articles of the Budapest Convention, which is here in 2 different languages, English being one, as the benchmark against which the bill is to be tested for compliance with that convention. Now, I am aware the Law Reform Commission, on whose behalf I speak and on whose behalf I am here, in the light of certain public criticisms of the bill, have authorized me to discuss the issues under various heads to determine whether there is any validity whatsoever in the criticisms that have appeared in the print media. First one is freedom of expression or freedom of speech under the Constitution. The second one, which I will address, refers to the provisions of the bill which touch and concern the issue of freedom of speech. Thirdly, I look at criticisms of aspects of the bill, repeating them, and then fourthly, analyzing those criticisms. Fifthly, I will give a summary of the Law Reform Commission's position. And finally, I will look at the terms of reference which were sent to me last week, your terms of reference that were circulated. Beginning first with freedom of speech under the Constitution. What I will have to say will be old hat to Mr. Thorne as a lawyer and the other lawyers here. But I have to say, I'm going to take my time and go through this so that there is no doubt as to what the law is in this country. Beginning first with Section 11 of the Constitution. At Chapter 3, and I quote, "Whereas every person in Barbados is entitled to the fundamental rights and freedoms of the individual. That is to say, the right, whatever his race, place of origin, political opinions, color, creed, or sex, but subject to respect for the rights and freedoms of others and for the public interest, to each and all of the following, namely A, life, liberty, and security of the person, B, protection for the privacy of his home and other property, and from deprivation of property without compensation, C, protection of the law, and D, freedom of conscience, of expression, and of assembly and association." The following chapters, provisions of this chapter, shall have effect for the purpose of affording protection to those rights and freedoms subject to such limitations of that protection as are contained in those provisions, being limitations designed to ensure that the enjoyment of the said rights and freedoms by any individual does not prejudice the rights and freedoms of others or the public interest. So that is the general statement about fundamental rights and freedoms, which the Caribbean Court of Justice has held is justiciable. In sections 12 to 23, the individual rights are spelled out in detail. The one that concerns us this afternoon in relation to the bill before you is Section 20. Section 20 deals with protecting freedom of expression. And the way sections 12 to 23 are constructed, what you have first in the first subsection of all of them is what I call the imperative right. And then you have in the second subsection, subsection 2, a derogation, the circumstances on which you can derogate from that imperative that is set out in subsection 1. So subsection 1 says, except with his own consent, no person shall be hindered in the enjoyment of his freedom of expression, and for the purposes of this section, the said freedom includes the freedom to hold opinions without interference, freedom to receive ideas and information without interference, freedom to communicate ideas and information without interference, and freedom from interference with his correspondence or other means of communication. So that's what I call the imperative. Now, subsection 2, which derogates from that, sets out the test. The test for determining the constitutionality of any law, so that it is against section 22 that this bill must be measured to see whether it is constitutional or not. Subsection 2 provides, and I quote, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section to the extent that the law, meaning, for example, this bill, makes provision A that is reasonably required in the interest of defense, public safety, public order, public morality, or public health. Stop there for a minute. If the bill is reasonably required in the interest of one of those that I mentioned, you can't say that it is in contravention of subsection 1. The alternative, if the law in question makes provision B, that is reasonably required for the purpose of protecting the reputations, rights, and freedoms of other persons or the private lives of persons concerned in legal proceedings, preventing the disclosure of information received in confidence, maintaining the authority and independence of the courts, or regulating the administration or technical operation of telephony, telegraphy, posts, wireless broadcasting, television, or other means of communication, or regulating public exhibitions or public entertainments. So that's the test set out to determine whether the Cybercrime Bill 2024 is constitutional or not, or if any provision of it is unconstitutional. We may come to those in due course. So I think it is important for me to emphasize that what I read is clear in its intent that such limitations as there are on the imperative are designed, quote, to ensure that the enjoyment of the rights and freedoms by any individual does not prejudice the rights and freedoms of others or the public interest. So in short, the right and freedom of expression is not absolute. It is subject to limitations. Now, we have to test the bill against section 20, subsection 2, to determine whether it imposes limitations in the interest of public morality, public order, or for the purpose of protecting reputations from defamation and so on. Those provisions in the bill which deal with freedom of expression, if we may look at them as we go along first, section 16, dealing with child pornography. This was formerly section 13 of the Computer Misuse Act. Although the section criminalizes child pornography, indulging by different means, it provides a defense. It provides a defense in subsection 2. If a defendant can prove that, quote, the pornography was for a bona fide research, medical, or law enforcement purpose. So if you are charged and you can bring yourself within one of those categories, you may have a defense if you indulge in child pornography. I would think, however, it's a fairly heavy threshold to attain. The next one, I'll come back to looking at the language of this section in detail, because perhaps in passing I better mention that if you see section 16.1 or clause 16.1 as it is now before you, it says a person who intentionally or recklessly does a whole series of things.
So David, are you taking questions as you go along?
I can, no problem, I can.
I just wanted to ask you, I'm looking at subsection 2, the defense.
The defense?
Yes.
Yeah.
And this bona fide research, that causes me some difficulty.
It would, because it is difficult to see how it is achievable.
Well,
but it's better
in terms of definition, what is bona fide research?
Well, you would have to, the defendant would have to convince the court that he had these pornographic things because he was writing some learned academic paper about, and if he could, I suppose, and let us say he was from an established university, and it could be shown that it was with the approval of the university that he was engaged in this research. The convention allows for that sort of thing.
Consistent then with what you're saying, Sir David, I'm wondering if the legislator may not wish to extend it in the way that you have defined it.
Well, that would be for the drafters to do.
Yes.
And I am not one. I'm not a lawyer who says he can't draft, because I believe that words are vehicles of thought.
Oh, yes.
And a lawyer must be able to draft.
To say what he means.
Say what it means. You have to do a contract, or you have a client who comes to you with a contract. And what are you going to do? Tell him, well, I'm not a drafter? You're going to give him the best possible legal advice you can. So I'm not one who, not a lawyer who believes that because you may not have been a draftsman properly trained like Ms. Drix, that you are not, at the same time, capable of drafting accurately.
Yes. Well, thank you very much, Sir David. I just felt that since it is a defense, it is a defense, important as defenses are, the draftsman probably needs to give larger explanation, consistent with what you have submitted.
Sure, yes.
A recognized institution, university, research center, I think the draftsman may need to extend it, to extend the definition rather than just say bona fide research. Anybody can claim bona fide research.
But you know the old factor, I used to say bona fide claim of right.
Yes, correct.
No more, because there are so many variations of a claim of right.
Yeah.
It could arise in several different fact situations or fact matrices.
Yes. Well, thank you, Sir David.
I'm
sorry.
The drafts, not at all. The drafts people can look at that. Sure.
Thank you, sir. Thank you.
So David,
Sure.
Just as a little follow-up. Now, I am not a social media person.
Nor am I.
But, you know, I would take up my phone, open it on Facebook, and I get all kinds of things which, in my view, are really bordering or pornographic and various other things. Now, I haven't gone on any site and downloaded or anything, but they are there. So how can we be protected in situations like this.
Well, if you were offended by it, I would advise that you report the matter to the police. You're going to bring me to a point where I didn't necessarily intend to come at this stage, but let me just tell you my own experience. I am not going to play this one because it is so disgusting, and especially as this is streamed. I'm not putting this back out again. I had to report this to the police in 20th of July 2022. I can pass it around at you, see if you like, or show you privately after. It was an advertisement for oral sex competition to be held in St. Philip. And the nastiness was displayed large and loud for everybody to see. This was sent to me. And I was so disgusted by it that I sent it, as you will see. Right. See, the ASP. I sent it to the police for them to follow up on it. I didn't have any difficulty when I saw that. I knew it was pornography. Right. So, as a citizen, my next step is to report it to the police, because I'm an ordinary citizen. In fact, some will say that I'm irrelevant, but my thing is to report it to the police. Okay?
So in this case, what you're saying, the onus is going to be on the individual
If
to
you
report.
if you are offended by it and you think that it crosses the line, I think you should take it a step further and report it to the police. It will not be public mischief, it will be public good.
Okay.
So David, in your view on this same section, bona fide research and medical purposes, should, with the consent of parents, also be added, with parental consent, for this to be achieved and to be a defense?
I would prefer to defer to Chief Parliamentary Counsel for the reason that I think you may need to check what is in the child protection legislation and the child justice legislation before you take a definitive position on it. The three may have to be cross-referenced to get a true picture.
Chair, I don't think the parent can consent to a breach of the child's rights, and the child has the right not to be a subject of pornography. So parental consent would not be a defense.
No, but I meant within this context, not outside of this context. Within the context of the research and the medicals and the law enforcement.
It would be a dangerous thing to mention parental consent, because you're already sacrificing the child.
Yeah.
And a lot of pornography against children is committed by parents. Some knowingly and some unwittingly.
No, but practically speaking, how would you get a child to be subject of bona fide research and medical and law enforcement purposes without the knowledge of the parent, and for it to be legitimate? Excuse me, I'm in compliance still with this law and as part of the defense to a charge.
I would think the researcher makes the judgment whether the parent consents or not. The judgment has to be made by the researcher as to whether it is bona fide. So I would feel safe leaving it with the researcher as to the bona fides as to what he is doing, in spite of the parent's feeling. Because as Sir David is suggesting, you go to the parent, you're opening up a whole new area.
Oh, yes.
Yeah. Which may be in other legislation.
In other legislation.
Yeah. Yeah.
David?
Yeah.
Yeah, there's a tremendous amount of, unless you're a historian, this is just along the same line of research. Unless you're a historian, you may not necessarily know there's a tremendous amount of images, information out there in various libraries and universities where historic photographs of children, historic, dating back from maybe from periods of slavery and periods in between there, the early days of photography. In many cases, that information is held by persons who might have been curators of these various museums and archives and all such like. That information is shared during the process of study. But after that period, that information is kept. But for the purpose which that information was first gotten, it was first acquired, it was through the process of research or through the process of study. But it remains with the person. It is historic. There's one instance of it's historic. It dates back 60 years, 70 years. It may be of some group, ethnic group, some remote part of planet. So where the cultural differences are obvious, and C, though it would have been obtained during the process of study, you study that period has passed and you still have access to that information. I did my PhD 10 years ago. I still have records of some of the footage from that period. That footage is now found on my computer. What happens in a situation like that?
That was bona fide research.
It was.
It was.
10 years ago.
Yeah, yeah. You
20
can
years
prove that
ago.
it was part of your thesis or whatever. It was valid defense. It doesn't mean that it has to be current. That defense doesn't mean it has to be current now. So long as you can show it was bona fide whenever you were engaged in it, it'd be a perfect defense. There are laws in the criminal law which use that phrase bona fide as a defense. I can't remember all of them offhand now.
And as the first point I made about information made historic, being dated back 18, 19 years ago, you know, persons would have, even out of their own curiosity, you know, they may not be attached to any university, but might study various ethnic groups, you know, for their own interests.
I could see a situation, you know, in England in the last 10, 15 years, a number of entertainers or DJs, disc jockeys, were found to have been involved in child pornography while they were at the height of their popularity. Jimmy Savile, I think, was one. Now, if there's a researcher who comes along now to look at why, and you know, you can never tell why people would write for a PhD or what subject they would choose, but someone might say, well, look, I would like to find out what motivated DJs in the 60s and the 70s to do this. Maybe 5 or 6 cases in England and maybe elsewhere in the state. And somebody chooses that niche for investigation. I think he has a case to say, this is bona fide research, once it is supported and so on. And it is that if you use the images and so on, that will be protected by that piece of legislation, that defense that is given by subsection 2. Child grooming is the next one at section 17. This is new. This was not in the original Computer Misuse Act, but it is one of the modalities of cybercrime, contemporary cybercrime, that you will see in other legislation. But I wish to emphasize at this stage, and I will later on also, when you read these clauses, these sections, they all say a person who intentionally or recklessly uses a computer system for whatever purpose is guilty. It's very important to understand that this legislation does not create any absolute offenses such as you may have in a regulatory system that looks at small crimes like not having a bicycle light or a little, you still have them licenses. In my day, you used to have a license on the back in the heart shape and so on. Right? But those are regulatory things. So don't worry too much if there is no mens rea in those types of offenses. Those are strict offenses of strict liability. This legislation does not contain any offense of strict liability. Every offense requires proof of mens rea. There's actus reus and mens rea. The act and the guilty mind that accompanies that act. So when you see here a person who intentionally or recklessly uses, the Convention on Cybercrime itself in its article speaks all along of intentionally doing something. Those words in themselves give a defense. Give a defense. If you, all right, take any offense there. Somebody sends you, oh, take that one that I showed just now. And somebody sent it to me. And before I could properly look at it and understand it, my finger sent forward and it meant the Dr. Springer. And he got offended and he went to the police. My defense would be, well, that was pure accident. I did not intentionally send it to him. It was an involuntary act, not directed at him at all. But it went, I couldn't call it back, it went. So that is why it is important to understand as we go through this bill, right through the bill, we have provided for defenses within the definition, as well as defenses separate and apart. Defenses within by the use of words such as intentionally or recklessly or without authority. Those offenses which relate to access to the computer, breaking into a computer or getting people's passwords, you might see the words without authority. That is that nobody gave you the authority to go into it. All based on the convention itself. Online child sexual abuse, this is another one that is a new one. Clause 18, again, a person who intentionally or recklessly uses a computer system to meet a child for the purpose of engaging in sexual activity with the child, or where coercion, inducement, force, or threat is used, etc. It's all there. We've tried to make the language of this act as simple and intelligible as possible. We haven't dressed it up in a lot of legalese to make it complicated for the public to understand. Now, the one that will give you that has given the greatest, I suppose, opportunity for comment has been Section 19. But in the meantime, let me just look at Section 21 first. 20, subsection 1, cyberbullying. Same thought again, a person who intentionally uses a computer system to publish, broadcast, or transmit data that is offensive, pornographic, indecent, vulgar, profane, obscene, or of a menacing character, or causes such data to be so sent for the purpose of causing annoyance, inconvenience, danger, obstruction, embarrassment, insult, injury, humiliation, intimidation, hatred, anxiety, or causes substantial emotional distress, is guilty of an offense and liable to conviction, etc. These are newish offenses, cyber crimes, that have come into vogue in the last 4 or 5 years, I would say. And we were encouraged to be as current as possible with this legislation by the Council of Europe, who administer the Budapest Convention, and keep that up to date. And I will say something about them later and the assistance that they have rendered us and Barbados in the preparation of this legislation. I don't need to say anything about cyber terrorism. That speaks for itself. Clearly, if somebody intentionally uses or accesses a computer system for the purpose of terrorism, that is nothing to be sneezed at, carries some heavy penalties, as I will discuss later. Now, I want to revert to malicious communication because, as I said, when I come to analyze the criticisms, they tended to focus on Section 19.2 and 19.3. 19.1, a person who intentionally or recklessly uses a computer system to publish, broadcast, or transmit computer data that A, intimidates a person, or B, threatens to use violence towards a person or a member of his family, or to damage the property of a person or the property of his family, guilty of an offense, liable to a fine of 70,000 or imprisonment of 7 years, or both. Subsection 2, a person who intentionally or recklessly uses a computer system, A, to publish or broadcast or transmit data that includes private sexual photographs and videos without the consent of a person who appears in them. Now, with intent, it's not just using, with intent to humiliate, harass, or cause substantial emotional distress to that person, or B, to send repeatedly to another person data that is obscene, vulgar, profane, lewd, or indecent, again, with intent to humiliate or harass the other person to the detriment of that person's health, emotional well-being, self-esteem, or reputation. And these words such as emotional well-being, self-esteem, and reputation are finding their way into legislation, contemporary legislation, because misuse of computers and malicious communications have had all kinds of negative impacts on recipients and people who were targeted for the purpose of humiliation or ridicule or whatever. And the law is there to rein in some of this conduct and some of this behavior without trampling on the right to free speech. You can speak freely, but that doesn't mean that you have the right to curse somebody beyond the burial ground by telling a bunch of lies on them and so on. It doesn't mean that you must humiliate or ridicule somebody. If you do that, then you're mashing the crease and the umpire's finger going out.
Mr. David, I wanted to ask you, since you've had the benefit of the literature, how the Europeans feel about this, because
very strongly.
You said you don't look at social media. I think Senator Nurse said the same. Social media every second of the day is about insulting, humiliating, embarrassing. How have the Europeans addressed that in their prescription?
In the most stern ways.
Really?
The most.
You can quote social media and every page is an insult, humiliation.
Yeah.
I mean, you're talking about the victim's peculiar sensibilities, but social media is riddled with it.
Yes, it is. It is.
And I'm curious as to how the Europeans feel. Are they condemning it, or are they giving some latitude
No,
to,
no, no,
to
no.
the
no.
writer.
No, they are very, very tough.
They're very strict.
The toughest of all is Britain.
Britain.
Britain has just introduced, you may see it on your Google, something called online, I think it's Online Safety, and Online Communication Act or something like that, last year. Got 126 sections. Tough, tough, tough.
And they're charging people?
I get the Times newspaper every day on my iPad, but I haven't seen that yet. I saw when there was a heavy debate in Parliament about that bill.
But Sir David, I'll tell you, your generation knows about a middle-of-the-road cursing. A middle-of-the-road cursing. That happens every 5 minutes on social media. Somebody starts a conversation, like the paper would put up something, and the people start cursing each other. And insulting each other.
Yes, yes, yes.
I assume that under this, they're committing an offense.
Oh, yes.
And they assume they're not going to get charged because it's so commonplace.
I don't know. It depends if somebody takes exception and takes umbrage at what we said about.
Like the All Blackguard legislation.
Well, you know, we had that. It's still part of the law, I believe,
Yes.
against the Highways Act.
Yes.
I wish the Ministry of Transport and Works would send and ask us to do something with that legislation. As the Law Reform Commission, we could certainly beef it up. But there used to be a poor man's
Defamation.
slander or defamation in
Yes.
Barbados.
Yes.
Cursing at the standpipe. Cursing at the standpipe was one. Using abusive words at or near
Yeah.
a highway. That's
Yeah.
the your legislation, right? All those things. Don't worry with them now. But when I came back to the bar in 1970, that's how some of us survived in the early days. You know, those standpipe cases, we got a couple of dollars to keep us going.
Yes. Bobby Clark.
Yeah. But let's look at this because there have been criticisms which I will come to show that they're not merited. Subsection 3. This is taken partly from the existing law and partly from what we've done is to abolish criminal libel that is in the Defamation Act, Chapter 199, and transported some of it into here, 19.3. So this now includes the phrase, let me read it first. A person who intentionally uses a computer system to disseminate any image or words, not caring whether they are true or false, and causes or is likely to cause or subject a person to ridicule, contempt, or embarrassment is guilty of an offense, and so on. Now let me just show you the type of thing I mean by looking at another one on my phone here. If I can find it. A few weeks ago, there was a big controversy in Barbados concerning a tower that was erected by Digicel down in St. James. And I suppose the bloggers and everybody had a field day. Social media must have been full of foolishness. The lady who heads up Digicel, so far as I am aware, is the wife of Minister Abrams, Wilfred Abrams. I know her as Natalie. I do not know what was her name before she married. On the 14th of April, this is what somebody called at Pat Sudat 189 sent out. She is David Simmons' daughter. Corruption. Okay. She is David Simmons' daughter. Corruption. No, she's not my daughter, of course. My daughter's named Maria, as the Honorable Leader of the Opposition knows. That is something that was published on a computer system recklessly. They didn't care whether what they were saying is true or false. They wanted to drive David Simmons' name in there and then put corruption on it and accuse the lady of being my daughter. That's the kind of thing that this legislation deals with. If you tell me that this is bad legislation because you seek to protect people's reputations from viciousness, then I disagree with the park company. Now, as I will show when I come to the defenses, apart from the defense that is implicit in the use of the word intentionally in this section, look at clause 19.5. We went to great lengths to say that, quote, the defenses of truth, comment, triviality, privilege, whether absolute or qualified, provided for under the Defamation Act shall extend to a prosecution under subsection 3. Okay. Suppose P. Sudat, I'd gone and complained to the police. Suppose this was enforced and I'd gone and complained to the police that this person published this thing recklessly, not caring whether it was true or false about me. And he or she had a defense. They could resort to 5 to say, man, oh, that's something's not well. That is trivial. They could raise the defense of triviality. If it was true, having said it, they could say, but it is true, and I will stand on that, go to court and prove that it is true. And we'll get the birth certificate of the lady and show that on that birth certificate, the father is David Simmons. That's how it could be done. You have the defenses written into the law. We have not been unfair to anybody. We have been very generous to put in the law what defenses you can rely on if you, God forbid, are charged. They're there. But I will show that in none of the commentaries by all of the people, I have the list, I have the clippings here, all those who have written, not one has drawn attention to section 19.5 to say, but the people give us defenses. If they're true, we can rely on that. Yes, Honorable Leader.
Yes, so David may then suggest that the legislation extends itself because these are civil defenses.
Yeah, but
the standard of proof is
they're given in a criminal case.
Context.
Yes, yes.
But if you want to establish your defense, are you doing it on a balance of probabilities? You must be if it's a civil defense.
If it's a defense, you only got to go on probabilities. You don't have a defendant.
As opposed to prove beyond reasonable doubt.
Defendant never has to prove beyond reasonable doubt.
Well,
the prosecution must. Am I wrong?
You're right. You're right.
Right. Yeah. You're right. The prosecution must prove beyond reasonable doubt.
In a criminal manner.
In a criminal manner.
But here it is, you're given a civil defense.
In a criminal manner.
In a criminal manner.
Yeah.
But the defender must establish his defense, presumably on a balance of probabilities, on a lower standard.
In a criminal case, you're right.
Yes.
Quite right, yeah.
So you're importing civil standards of proof into.
But giving it a defense.
Yes.
I'm saying
yes.
you don't have to reach that threshold
Precisely.
of absolute
Precisely.
Proof beyond doubt.
Yes. Yes. Beyond reasonable doubt. Yes.
As long as you raise it like any other criminal defense, it will be good and you just rely on the language of the particular defense in Cap 199.
So David,
Thank you for that.
the question could be asked because subsect 5
Yeah.
extends this defense only to
Only
prosecutions
to
under
3.
subsect 3.
Only 3.
Why not to those under subsect 1?
1,
Yeah, for intimidation, not for threatening to use violence or damage to property.
the defense is,
Why wouldn't it extend to the defense of intimidation of a person?
a defamation defense can't extend to something like that. A defamation defense only extends to something that approximates to defamation. Not intimidation, but let me,
Even
we define-
within the
we-
definition here of intimidate,
at
to
subsection 4, we
include a
define
person,
intimidation.
right, a person's, causing a person substantial emotional distress. It couldn't extend, I'm just playing devil's advocate here, of course, couldn't extend to that definition.
No, I think you'll be stretching it.
You'll be stretching it.
Yeah.
Okay.
Shall I turn now to the criticisms?
Yeah. Sure.
Shall I turn to the criticisms now?
Yes, please.
Okay,
Sure.
thank you.
Yeah.
I've summarized them, but I have them all here, the clippings from the Nation newspaper. The first one was Mr. Peter Thompson on the 4th of February in the Nation. It said, among other deficiencies, Part 219(1), I don't know what that means, imposes a fine of $70,000 and 7 years imprisonment for transmitting computer data that intimidates a person, even if the data is completely factual and in the public interest. Furthermore, Part 221 criminalizes speech that is deemed offenses and causes anxiety or emotional distress. Let me take that one first, 21. 21, it is true, criminalizes speech that is deemed to be, transmits data that is offensive, pornographic, indecent, vulgar, profane, obscene, or of a menacing character. But it says a person who intentionally uses a computer system. It doesn't just criminalize it. It criminalizes it if you do it intentionally. And he talks about this vague language is deeply problematic and can be leveraged to prevent criticisms of politicians and public personalities or political persecution. Well, I won't comment on that. The next one was Ms. Stephanie Chase on the 8th of February. She alleged that freedom of expression is under threat from state and non-state entities, criticizing section 19(1) and 21 as including vague language. Now, the language that they're saying is vague. Is where we use words like pornographic, indecent, vulgar, profane, obscene, or of a menacing character, or in 21B, for the purpose of causing annoyance, inconvenience, danger, obstruction, embarrassment, insult, injury, humiliation, intimidation, hatred, anxiety, or substantial emotional distress. Now tell me, first of all, the interpretation of those words is a matter for the court. But before you get to court, you have to pass the police. I go back to the one they published on me. Suppose I took that to the police. I would give my statement. The police officer is bound to ask me, but how has this affected you? It's just that when, honorable leader of the opposition, when you're doing a threats case, you let the witness or the client give his evidence. But one question you do not omit is, when he told you those words, but he's going to kill you, how did you feel? How did that affect you? And then the person said, I was frightened. I was real frightened. The magistrate write down that. That is the evidence of the effect of the words on the person. Just here, I go with this and show the police. And they ask me, well, how has that affected you? I say, first of all, it has held me out to be a liar. That all along, I've told my family I only had one daughter, but they gave me another one. And I've been humiliated. And he was saying, the policeman was saying, yeah, I see the word humiliation here. They would charge the offense that you intentionally use P. Sudat, or whoever the person that sent this one, P. Sudat. You use your computer on the 14th of April to write and so about David Simmons and to humiliate him using the language of deception. That's all they got to do. That's all they have to do. So that these words that they've called vague, such as indecent, vulgar, profane, obscene, embarrassing, insulting, injurious, humiliation, and so on, first of all, they're all words that have been judicially decided and on which the courts have had over the years to opine and define. And there are words which go to evidence and how the particular data or matter that was transmitted affected you as the person who was the recipient or about whom it was said. So these are things that go to evidence. They're not vague. And you will see when we come to look at other legislation, that they're all there in other legislation. I got Nigeria, I got Guyana, Seychelles. Then there was Marcia Weeks on the 8th of February. She said, some Barbadians believe that the bill would infringe their constitutional rights. It's an overreach. The bill does not infringe anybody's constitutional rights, in particular the right of freedom of speech. As I've tried to explain, it is only where you do something intentionally or recklessly within the context of a particular subsection that an offense is committed. Colville Mounsey of the 9th of February in The Nation wrote an article in which he repeated the criticisms of those persons I mentioned, but not once, and this is my criticism of the press, not once in an article, not a comment from somebody, but I think a newspaper has a duty, if you're going to write a whole page about some aspect of a bill, you have a duty to set out the law as it exists. Not once did the nation condescend upon a citation of the particular section that was inveighed against. And I think that it's not fair, it has misled the public into believing that if you just publish something, it is infringing of freedom of speech, although the law has said intentionally or recklessly. 23 times in this bill, 23 times, that phrase intentionally or recklessly, or the word intentionally, or the phrase without right, is used to import a notion of mens rea, mental element. Well, my former personal assistant, Mr. Caswell Franklin, on the 11th of February, he is quoted as saying to a crowd, "With this bill, you can be sent to jail if you say something which hurts someone's feelings. But if it is true, it cannot be defamation. Yet this bill is saying you can be prosecuted whether it is true or not, which is contrary to our law." That's wrong. I read the section of 19.3 about making a statement recklessly not caring whether it is true or false. The word recklessly appears in the existing Computer Misuse Act. It is an offense. But it is where if you use a set of words recklessly, but they're true, I've shown you have a defense under 19.5 to show that the defense of truth, which presently exists in the Defamation Act. Michael Ray was the most recent I had on the 15th of February. And I'm not sure what to make of his article or letter, but he said there was an increasing number of social media users are complaining about getting hacked. This deals with hacking. B, unknown people are using names and images to send false and damaging information across cyberspace. True. Persons are being threatened and blackmailed. True. People are afraid to make online financial transactions for fear of being hacked. True. I am one of them. E, computers are being used to transmit pornography. True. F, computers are being used to assassinate people's characters and make false accusations. Again, true. That's my career. But this is how he ends off his article, having spoken so many truths. He calls for a bill to be written in a way that, quote, protects thousands of sitting duck Bajans and protect the vulnerable and innocent. Nice words. I'm not sure what he's meaning. But this bill, I believe, protects all kinds of Bajans, high or low, if somebody uses a computer system to propagate nastiness about you. Mr. Kimar Stewart, he said it is true. He was cited in an article. I thought I had it. Oh, the 4th of February, yes. He says it is true that if bloggers commit any offenses by malicious communications, they can be prosecuted. That is the existing law of Barbados. But we have built upon that and expanded it because in 16 years, as I said earlier, the march of technology has been so swift and relentless that people have used computers and computer systems for all kinds of nefarious purposes. He said, why should a blogger wish to publish untruths about people and gain a reputation for disinformation? Well, I can't answer that. not having analyzed any of the sections of the bill, he says it is unfair, untrue, and almost blasphemous to suggest that users of social media would have little or no free, would have little or no free speech. I would only ask Mr. Stewart to go and read the sections as I have read them for him, using the phrase intentionally or recklessly, or where defenses themselves are specifically created and written into legislation. You will see it there. No, sir.
So David, may I ask quickly,
Yes, yes.
has any explanation been given for the severity of the penalties?
No, well, you like me to come to them?
I was
Okay.
gonna ask that
I'll
question
defer,
too.
I'll defer, Chair.
I was gonna ask that question. Yeah, what's your feeling on the penalties, whether you feel they're too harsh? So,
No.
yeah, not only on that section, the penalties throughout the bill.
No, I have a matrix here. I can,
Interrupted, you hadn't finished the criticisms, so I was probably previous.
yeah, I was finished.
Oh,
I was
okay.
finished.
Yeah.
Mr. Stewart was the last one.
Right.
I'm very curious, like Chair, I'm very curious about.
Yeah, I have a table of penalties.
Yes, thank you.
No, first of all, let us understand two things. The Law Reform Commission, which prepared this bill with the assistance, the direction and the sponsorship of the Council of Europe, who supervise and superintend the Budapest Convention. We are only a recommending body. We do not implement. No law reform commission anywhere in the world implements law. They may recommend the introduction of a particular, piece of legislation saying one thing or the other. But it is up to the government, when we send forward a bill, to determine whether they are going to go with the penalties as recommended or feel free to change them. The penalties in this bill, fortunately or unfortunately, have not been tampered with by the government. They are exactly as we sent them forward. And in doing that, we had State Council assigned to the Commission go through and do an analysis of legislation in this region where there is similar legislation to see if we are in the ballpark with those penalties which we recommend. And I can say to you that the research, and I will let you have this because it's all on computer. I'll let you have this. You can make copies or have me send it. It'd be easier if I send it again as computer data, and then you copy it and circulate to all your members. Right? This is on our computer. But let me just run through, and as I go through, you could make a note if you think it's too high or whatever. That's not for us to determine. All we did was to make sure we were, as I say, in the ballpark, fairly well aligned with what other countries, and in particular Guyana, is doing. Because some of this legislation is close to Guyana because they're the most recent. Some of the rest of the Caribbean is behind. Now, take clause 4 first, illegal access. Conviction and indictment. We are proposing 50,000 or imprisonment for 5 years or both. Guyana, they have 48,353 Barbados dollars. They speak in terms of millions, of course. 5 million Guyana dollars, but when I boil it down, it's only 48,000. You say 50, they say 48. It's for you all to decide if that's too high or.
And the imprisonment as the alternatives in the sections to
Both of us go for 5 years.
5 years. Yeah, okay.
Clause 5, modification of program data. Well, this is a new offense. There's nothing really comparable. Jamaica does have something, but again, it's not comparable because Jamaica talks of first offense and second subsequent offense. And we don't have that. But they have, in the case of a second or subsequent offense, regardless of if any damage is caused or not, a fine not exceeding 5 million J dollars, which is 65,169.44 of our money. And we are saying 70,000. We are 6,000 higher. And Jamaica, I think their legislation is about 2015. So we are a lot more up to date. Clause 6, interfering with program data. For conviction on indictment, we say $70,000. Guyana, the 70,000 or 7 years. Guyana has 77,365 because they speak of $8 million or 5 years. So we are 2 years more, and we are 7,000 less than Guyana. Interfering with a computer system on indictment, 70,000 or 7 years. Guyana, again, 77,365, 8 million Guyana dollars. That was clause 7.
And how many years?
Yeah.
Yeah.
5 years. We said 7.
Maybe these are maximums.
Yes.
Discretion is not lost. Judicial discretion.
No. It means liable to or up to.
Yes.
Yeah. Illegal interception of data, 100,000 or 10 years, we say. This is a serious one. And we don't have intercept legislation, but interception of data, somebody hacking into your computer. 8 million Guyana dollars again, or 5 years. We are higher, substantially higher. We have about $23,000 more than Guyana in this one. And 5 years more also. You may wish to change that if you.
Section.
That one was clause 8. Clause 9, illegal devices, 70,000 or 7 years. Guyana is 77,000 or 5 years. When I say Guyana 77,000, that is the conversion into the Barbados equivalent. Clause 10, 70,000 or 7 years. This one we can't work out very easy. Guyana says in their section 23, 4 times the monetary value provided by that law, and of course the same custodial sentence. So they're really not helpful. Jamaica, in relation to a second or subsequent offense, is 65,194 Barbados dollars or 5 million Jamaica dollars, whereas we're saying 70,000. There's a $5,000 difference there. And as I say, we are 8 years ahead of Jamaica. Their act was 2015. Disclosure of access codes, 25,000 or 3 years in clause 11. Guyana is 29,000 or 3 years. They're 4,000 more than we are. On indictment, They are 77,000. On indictment, we are 70,000. Now, clause 12, critical information structure. This is very important. Having regard to the experience we had last year with the QEH, when somebody hacked their systems, we have written in, with the help of the Council of Europe, this definition really is theirs, that we refer the matter to them to get the latest and best definition of critical information infrastructure. But I would advise the government as early as now to ensure that there is a protocol shared between departments which have critical information infrastructure that we identify in clause 12. In fact, this is so important. Why don't I read it into the record? Clause 12. For the purposes of this section, critical information infrastructure system means any computer system, program, or data that supports or performs a function that relates to A, electricity generation or distribution, B, telecommunications, C, government services, D, emergency services, E, law enforcement, security, or intelligence agencies, F, public works, or G, the catch-all, any computer system, program, or data that may be designated as a critical information infrastructure system by the minister responsible for, and that is for the government to write in which particular minister, published in the official gazette, that is so vital that the incapacity or destruction of such computer system, program, or data would have a debilitating impact on the security, national economic security, national public health or safety, or any combination of those matters in Barbados. And I'm saying that I think the government should look at those agencies which we specify and develop a protocol now so that in case one of them is hacked, a whole set of actions follow. Just as we have for hurricane preparedness, and you bring the private sector to do all kinds of things. They need to do that because this business of hacking and critical infrastructure is not to be sneezed at. It is serious. It is internationalized nowadays. Because at the end of the day, somebody is hoping to get ransom out of it.
So David,
Sure.
the categories of critical infrastructural systems or critical information infrastructure systems can't be closed, of course.
No.
So are we satisfied with the provision there that the minister responsible for the crime prevention publish in official gazette any subsequent or any subsequently thought systems that may be of, national security importance, national economic security importance? Because, of course, the publication in the official gazette would therefore be by negative resolution laid in Parliament. Just for the records, for you to explain that process.
Does yours
for
say
the public.
the minister responsible for crime prevention?
The definition of minister in this act?
Yeah. I don't think so. This one, I think, is something for the chairperson of national security.
Okay,
This is one for the Prime Minister to head.
okay, because, yeah,
Any-
minister is not defined.
Huh?
Minister is
No,
not
no,
defined
it's
in
not
the
defined,
chart.
that's why we
No.
left it. There's a blank space there that has to be filled in. There are two X's. You need to, government needs to decide, and I think this is so important, that this is one that if you have a national security council or committee, this is the one that should be responsible for that, for implementing clause 12. It touches national security. It really is so important.
But to add to it would be by way of negative resolution in Parliament. Because this section.
I'm not sure I'm with you on that. In fact, I'm not sure that is something that should come to Parliament at all. I think it is, the government should have a policy that if the courts were hacked, so-and-so would happen, and it would trigger a response from various agencies, and we will take certain steps and certain actions. I can't go into them. I'm not a member of the government, but it seems to me that that is how I would approach it, and that was certainly our intent, because this critical information infrastructure runs through all contemporary legislation. And it is because the world recognizes what is happening with these vagabonds who hack the internet and your computers and so on. Getting at governments and banks and places like that. Private sector would have to be involved in this because they go after the banks. As we've seen in Barbados, we've had that experience 5-6 times. So I think that a policy could be fashioned between the public sector and the private sector as to how we would respond in a situation where there's a repeat of the Queen Elizabeth Hospital elsewhere. But I don't believe that that should go to Parliament. If it goes to Parliament, you defeat the purpose. Because the world then knows what you're going to do. Don't do it. Some of the others, clause 14, computer-related forgery. We are 100,000 or 10 years on indictment. Guyana is 77,365 or 5 years. We are higher again by about 23,000, and certainly we have doubled the period of imprisonment from 5 to 10 years. Clause 15, computer-related fraud. This is new, but Guyana has a similar provision, 77,365. We say 100,000 or 5 years. And then Guyana goes up to, oh sorry, that was on summary conviction. On indictment, there are 96,707 or 10 years. We had with them on the 10 years, but our fine is 100,000. We have 4,000 more than Guyana. Child pornography, clause 16. On indictment, we are 100,000 or 10 years or both. Guyana is $145,060 and imprisonment for 10 years or both. They are substantially higher for child pornography, 145. Child grooming, and this is the same as for porn, 8 million in Guyana, which is 77,365, we are 100,000. They're 5 years, we are 10 years.
So David,
Sure,
may I take you back to child pornography, please?
sure.
The penalty, in the case of a corporation, is there any, was there any thought given to
Later on,
the director?
later on.
Or later on?
The bill has it in.
Thank you, thank you.
Online child sexual abuse, 100,000. Is the same as for pornography. Those are all kind of standardized. Malicious communication, section 19. We say 70,000 or 7 years. Guyana says 96,000. Those that I was dealing with reckless or intentional dissemination of nasty material. Let me find your one. I thought we had a provision in this for corporations. Really, do we? I thought we did.
In
Just to
fact,
say-
Sir David, I was going to raise that as well, because Section 14 of the Jamaica 2015 Act, as you have correctly stated the year, speaks to that they have a separate provision for penalizing body corporates which commit offenses and penalizing the directors, the manager, director, manager, secretary, or similar company officer.
Yes.
But my eyes did not see that reflected in this legislation. Yeah.
Sure, what are the categories again?
Extending to the director, a director of it, manager, secretary, or similar company officer. Section 14. And it would be in your package.
Okay, thank you.
You gave the Parliament gave us the Guyana and Jamaica Acts in the package, right? No, I think by email for our first meeting, you will see that there. Yeah, the Guyana legislation and the Jamaicas for comparison. Ours is closer to the Guyanas, as David has correctly said, because Guyana is more recent than the Jamaicas. But Jamaica has that provision, Guyana doesn't have it.
No, Guyana has it. I'm going to read it.
Oh, Guyana has it as well too?
Guyana has it.
Yeah, okay.
Guyana's legislation is 20. Guyana's legislation is 2018. And section 21, Rhea, make a note. It says this: where a body corporate commits an offense under this act, the body corporate is liable to the fine applicable in respect of the offense. Straightforward, all right? Where a body corporate commits an offense under this act and the court is satisfied that a director, manager, secretary, or other similar officer of that body corporate, A, consented or connived in the commission of the offense, or B, failed to exercise due diligence to prevent the commission of the offense, that director, manager, secretary, or other similar officer commits an offense. A person who commits an offense under subsection 2 is liable on summary conviction to $5 million or 3 years, and on indictment, $8 million and 5 years. And I would recommend that we include that in our legislation. Provision for corporate liability.
It's very simple.
Well, I would leave the drafts lady to deal with that. The same response to the criticisms which seem to focus on section 19, particularly 19.2 and 19.3. The response of the Law Reform Commission is that the bill satisfies section 22 of the Constitution, 20 subsection 2, because it is reasonably required in the interest of public morality and public order, and also for the point of view of protecting people's reputation in defamatory cases, in defamation cases. Secondly, the bill can't be unconstitutional to the extent that it requires mens rea for the several offenses. And I pointed out that there are 23 times when the phrase intentionally or recklessly or intentionally, and sometimes without authority, is that kind of phrase is used. It is a protection against arbitrary conduct. It is a protection against arbitrary conduct being criminalized. That is where those people who have written in the newspaper have done a disservice to the people of this country, because they have not gone through the sections and analyzed them. They just say it criminalizes free speech. Not true. Not true at all. If a defendant can show, as I said, I did not act intentionally or recklessly, he has good defense to all those charges. Thirdly, in respect of section 19.3, the bill incorporates specific defenses from the Defamation Act in clause 19.5, one of the few bills that has done that. Fourthly, it does not threaten freedom of speech. What it does is to emphasize to citizens who may use computer systems that if they transmit data, provided that it is not offensive in law or injure the feelings or reputation or other members of society, they can transmit the data freely. What can possibly be wrong with such a law that gives you freedom to transmit whatever you like, provided you do not curse people and abuse their families and tell lies on them and so on? No. The legislation replicates many similarities from other legislation. As I said, we looked at Guyana, Jamaica has. Guyana is the best of those in this region. Then you have the UK, and I can mention also Nigeria and the Seychelles, just by looking at their, what we call them, arrangement of sections. For example, Nigeria. Part 1 deals with objectives and application. Part 2, protection of critical national information infrastructure. Designation of certain computer systems or networks as critical national information infrastructure. 4, audit and inspection of critical national information infrastructure. Part 3 deals with offenses and penalties against critical national information infrastructure. Now, these will become familiar with ours. Unlawful access to a computer, unlawful interception of communication, unauthorized modification of computer program or data, system interference, misuse of devices, computer-related forgery, computer-related fraud, identity theft, child pornography, and related offenses. They have one called cyber stalking and cyber squatting, cyber terrorism, racist and xenophobic offenses, corporate liability. Seychelles, similarly, unauthorized access to computer systems, access with criminal intent, unauthorized interception, unauthorized interference with computer data, unlawful possession of illegal devices, electronic fraud, system forgery, cyber extortion, cyber harassment, cyber stalking, offensive electronic communications, pornographic or obscene material, pornographic publication, and so on. So most countries, because of the way the convention is written, just to give you an idea, Article 4 of the convention. Each party shall adopt such legislative and other measures as may be necessary to establish as criminal offenses under its domestic law when committed intentionally the damaging, deletion, deterioration, alteration, or suppression of computer data without right. Misuse of devices, each party shall adopt, again, this is a standard way of expressing it, such legislative or other measures as may be necessary to establish as criminal offenses under its domestic law, when committed intentionally and without right, etc., with intent that it be used for the purpose of committing any of the offenses established in Articles 2 through 5. So our legislation is following faithfully the mandate given in the convention, in the several articles of the convention. And I go further. The Council of Europe last September sponsored at their expense at the Lloyd Erskine Sandyford Center a workshop to go through our legislation with us, clause by clause. First day was for judges and magistrates. The second day was for police prosecutors and the DPP's prosecutors. The third day, September 13th, was for service providers. And none of those participants criticized this legislation as being restrictive of freedom of speech. And on the second day, we had as many as 46 persons attending from the police and the DPP's office. At the end of it all, the officials in Budapest congratulated us on what we had done as the Lloyd Forum Commission and said that we now have in this bill the most contemporary and up-to-date legislation on cybercrime in Barbados, in the region. And I want to say that you have to be careful in confusing notions of cybersecurity, which is about systems and structures and so on, with cybercrimes. Cybercrimes are the ways in which criminals use cyberspace, particularly via computers, to commit all kinds of crime.
So David,
Sure.
good evening. First of all, let me apologize for being late. I'm not sure if you covered it, but when I came in, you were going through the various provisions. And I'm happy to hear you speak about the extent to which the freedom of speech is not unduly interfered with. But my concern is with Section 19 on malicious communications, and whether, in your view, the draftman has captured what you had in your mind as the behavior that intimidates a person. I say that against the backdrop of
That one of intimidation was
Yeah.
taken from the Guyana legislation.
Yeah, and the challenge that I have with that is that if you intimidated a person outside of using a computer, it is not a crime. And that there is some vagueness in the language that would require the interpretation of some policeman or some officer of the state to determine whether or not you are committing a crime, because intimidation in of itself is not a criminal act, and that the language here is vague or could be susceptible to an allegation that it is vague, and therefore lend itself to being struck down as in a similar way to how legislation has been struck down for lacking certainty. As recently as last year, the court, in my view, rightly struck down the old 19th century legislation that created the offense of wandering.
Oh, yeah.
Because if a child was guilty of wandering, it was an offense, but if an adult did it, it was not. And similarly, the case that comes to mind is the McEwan case out of Guyana, where the Caribbean Court of Justice laid down the principles about requirements of certainty in terms of legislation criminalizing behavior. So that what would constitute an objective standard behavior that is intimidating, and what would be criminal about it? And while there may be a reason to criminalize malicious communications via the internet because of the pervasiveness of the use of the internet to do things, there are people who might use outrageous statements or propaganda, particularly when it comes to elections and so forth, to cast a view or color the perceptions of people who might not necessarily have made up their minds one way or the other. But when does it become intimidating? And when does intimidating behavior become a crime? And I thought that this section perhaps was the one that I felt was problematic, in that it did not sufficiently express in detail and particularize the extent to which a person can be intentionally or recklessly, by way of a computer system, intimidating someone. If I tell you look too fat, and they put a joke or a meme, is that, where does the crime occur? In the mind of the person who apprehends and considers that they have been intimidated, or in the mind of an onlooker who is watching to see how is their objective standard? So this, to my mind, I'm flagging it here as in one that perhaps needs some kind of elaboration, because I suspect that if the bill passes in this way, this provision will not stand.
All right. Your concern is just with intimidation.
Yeah.
Not with threat.
Not the threats. We know what a threat is. Common law, we understand.
But we go further, the threat is violence towards a person, a member of his family.
And that is particularized.
No problem.
No, right. That is
So your
particularized.
concern is with 19(1)(a),
Yeah.
intimidates
A person. There are some very soft souls in the country
Yeah,
who
yeah.
might be easily intimidated by a meme or
And,
robust language or robust exchange, you know?
Therefore, you would want a deletion of 19(1)(a) and 19(4)(a), where intimidate is defined. Or I would ask,
Perhaps, David, for the purposes of section 1,
the word intimidate is defined.
is now defined in section 4.
They define there. The question is whether you think that is enough. That's what Guyana has in theirs too, I seem to recall. Intimidate has a definition. So I'm not sure what.
But I'm guilty of not reading the full section, so
Okay.
I apologize.
Okay.
I do apologize. But it is clear that it has a limited statutory
limited here.
definition here.
It's limited
And not the
here.
dictionary meaning of intimidation.
No, it has a specific definition in this, limited,
Yeah.
as between subsections 1 and 4.
In fact,
Ju- just-
four makes
just
it.
for the records, yeah.
If you wish, CPC to look at that.
Just to make sure that this is an exhaustive definition, and that's the parliamentary intent, because we wouldn't want it, but it is clear, it's clear here.
And I was,
Just for the record, Guyana Section 19 is comparable to our Section 19. And both of those sections are more detailed than Jamaica's comparable one, which is Section 9. But Guyana uses some different words. You know, they use like obscene and constituting a threat, menacing in nature, annoyance, inconvenience, distress, and anxiety. So the difference in some cases with the exact wording between the sections, but they're similar in their aim.
Mr. Chairman, I don't think that there's any difficulty in asking Ms. Drakes.
Yeah. Sorry, David, when I go through it, I want to be very clear, so that to intimidate means to cause a person substantial emotional distress. I think that is where
The person will have to give evidence as to how that affected them. And the court will then decide whether that was emotional distress or you're overplaying it or not. It's a question of evidence.
and the court determines it on an objective standard because they use the word reasonable
Yes,
in subsection 4.
correct.
So
well, it's not there, it's just
yeah, it's there in section 4, subsection 4.
right, but for 3, it doesn't say anything about reasonable, it says to cause a person substantial emotional distress.
No, but it's whether the things are true or false.
Right.
And then the consequence of that is that the person has been, is likely to cause certain person to be subjected to ridicule, contempt, or embarrassment.
So David, I'm glad you said that, but I am not reading that this is only where this can be where the statement or the interaction is true or false.
No, well,
In other words, if I were to put a caricature of someone for, let's say I blog and I'm known to blog about cricket. And I used to call a former West Indies captain by a certain name, and it brought me some kind of fame and notoriety because I did an interview once in India before a match.
is subsection 3 you're focusing on?
Yeah, so I'm just wondering if you were to say, call a fella Bigfoot, right? And that was to cause him emotional distress. There are some people who, especially sports persons,
There was one famous fellow who used to play cricket in the BCI competition. He didn't like you to call him a certain name.
right? Yeah.
Which related to poetry.
Yeah.
I will tell you after.
Yeah. So, but when we're in 1904,
No, go to 1905. When you read 1903, you've also got to read 1905 because 1905 gives you every defense that is known in the Defamation Act is applicable in 1903. That's why it's important to read the whole bill. The only bill that sets out specific definitions like that, you say, if somebody charges you here, as I gave the example of the person who said that Wilfred Evans' wife was my daughter, and they have corruption on it. That was saying it recklessly, didn't care whether it was true or not, but just using their computer to want to get, David Simmons is a nice name to lambaste. I said David Simmons. and then put corruption behind it.
So David,
But then the person could argue, well, that is trivial. So David too thin skinned. Or it is true. Or it is just fair comment.
Right, and I'm probing the extent to which we lawyers can argue these things, so that whereas
The leader of the opposition made a good point about those defenses.
yeah, the intimidation point is not known to defamation. Can it be that that is not available? Those defenses are not available where someone is charged for intimidating?
Intimidation.
In other words, are the defenses in subsection 5?
we raised that, Senator. Yes, I raised that before you came on that.
Only subsection 3.
The three.
For intimidating language.
Yeah, yeah.
So that's the challenge I have with the intimidating language, because what is the
No,
defense?
so David said earlier, it is not of the nature of a
Defamation action.
defamation.
So what would be
Wouldn't
the
have a
defense?
defense, a defamation offense, defense, I beg your pardon, applying to that.
Right. So what would be the defense if the intimidating language is true?
If it is true, then it may not be intimidatory.
So David, I'm not sure if you understand, I make myself clear, though, because if I can say something that is true that causes a person to be intimidated with serious emotional distress, but it is true.
But you wouldn't have a defense under the act.
You then go to the mischief rule.
But we leave
what?
Who determines that, the judge or the?
Yeah, the judge.
Yeah,
What?
the court has to interpret
The
that.
mischief you're protecting against. If you tell a man something and it is true, you can't be intending to intimidate him. It is true. So the mischief rule would tell you that the truth should not
And
intimidate.
that is clear. That is clear from the
Well,
legislation.
statutory interpretation.
No, it's not statutory interpretation. You're applying a rule. What was the mischief that legislation was
Precisely
getting
was
at?
protecting against.
But I think.
I'm not saying that it can detail the passage of the bill, but I'm just saying that I'm thinking that there are people who might necessarily be overly sensitive to being characterized and criticized or lampooned.
Mm-hmm.
And this now might become the basis of them bringing private criminal actions.
Private.
Yeah.
This allows private.
Mr. Chairman, with respect,
No,
I suggest that the committee should refer this for further consideration by CPC, who is next to you.
Yeah.
Let her look at it and compare with other legislation and so on. She may want to refine it. You've raised a point, but I don't think we can flog a dead horse.
No, I know, I understand, and I'm just making sure that if we create a statutory offense, I'm not comfortable that we can leave it to statutory interpretation and then the subjective opinion of the court to give somebody a defense under the act.
But cast your mind back to Lady Chatterley's level, when that was prosecuted under the Obscene Publications Act in England in the late 50s or early 60s. It's the court that had to interpret whether it was obscene or not. True. And it's the same thing here, the court has to determine. It is just like under our Highways Act, I think it's the Highways Act, where you charge a person for using language, abusive language, at or near or on a highway. And the court has to determine whether the language is abusive or there are a couple other words in there. I can't remember it all now, section 44 or something. The court has to determine the nature of the conduct or the language in this case to see whether it fits the definition of abusive or indecent. It's usually abusive or indecent.
So David, I have confidence that if you were the judge, that would be so, because I well remember your decision in Eudice Ramsey and St. James Beach Hotel, where she cussed her employer, and I represented the employer at the time. No, we represented we represented the employer at the time, and she used some very muscular language. And you said that it was the indecorous venting of the Barbadian spleen. We are a society of men and not of angels.
Yeah.
It was an obscenity that she used, but at the same time, it didn't go to the root of the employment contract. But will every judicial officer, I like to think of some that we have in the system now, interpret the legislation in a way that gives a person a defense? Where the victim is saying that I am seriously emotionally scared by this intimidating language or this intimidation that I've seen on the computer. And it may be true.
Yeah, but you still have to go back to the key words in the section. The person intentionally or recklessly uses a computer system to broadcast or transmit computer data that intimidates a person.
Right. And I want to expose him. I'm going to expose him now, you know. Listen to me tomorrow at 7 o'clock. You know, I'm intentionally exposing it, but it's still true. So I might feel that this expose that's coming tomorrow is going to, and I'm going to have the emotional distress. Can the police come at my door or somebody else's door before and arrest them? And then will they have a defense that is playable under the legislation? I know it's a new area, and I would have hoped that if we did create this new statutory offense, that there will be some certainty in the scope of the defenses available.
Senator Nichols, can we agree? Because I raised this before you came, and Sir David is suggesting that we can probably have the Parliamentary Council look to see if it is possible, because I had raised it with Sir David. He felt the defense could not extend to Section 1.
No, it doesn't. Specifically says
Right.
19.3 and 19.5.
Right, it doesn't know, but if whether it is legally possible, it can.
Oh.
Because I think that's what Senator is trying to say too, that if it is true, that, you know, you should have a defense.
Or if it's trivial.
Or trivial.
Or trivial.
Yeah. So I mean, I don't see any problem with extending.
And therefore, I think let's see if the Parliamentary Council can have a look at that, because I know that, yeah, from reading the criticisms, that's one of the issues that seem to be coming out, you know, that public figures, and, you know, public figures always interpreted as being a politician, will use that section, therefore, to say, you know, you have intimidated me, even though it comes out that what you're saying is true or trivial. So we can have public counsel look at it. Yeah. And I take your point, Senator, because I was going to raise that case as well, Ramsey, where Sir David, as Chief Justice, said, man, it's normal Bajan language, man, I can think. But they're not, yeah, I felt it was right. Because the lady, if I recall, was right in front of the woman's door. I could easily have hit her if she wanted to, but did not proceed to hit her or anything like that. It was over, I think her wages being messed up, worked out badly, she felt. But yet, Sir Clifford as well, Judge Clifford, as he then was, Judge Husbands, in a very similar case, which was cited in Ramsey, ruled the other way in a similar hotel case too, and said, you know, that fair had been established, etc. So there's some things that you have to be left to judicial interpretation. But we could have CPC look at that, all right?
And Senator Nichols, I know you're focusing on intimidation quite a lot, but if you go to 21B, there's several other offenses created there, which you may have been referring to several: annoyance, inconvenience, danger, obstruction, etc. So you don't, the prosecutor doesn't necessarily have to stay with intimidation. Look at 20 subsection 1B. There's several other offenses created there. Yes, yes. I think one would have an argument as to whether you should criminalize. And I expect, Sir David, that the public will come back at us and ask whether we should criminalize inconvenience, danger, embarrassment, insult, injury, humiliation, intimidation. Intimidation is mentioned there again.
Yeah, well, y'all could take out which ones you feel
It is
like.
wide. It is very,
It's
very
wide.
wide. Yeah, you almost cannot say
Because
anything.
the existing legislation is very narrow,
Yes,
and we look elsewhere to get some more width for that particular section.
Yeah.
Take Nigeria, for example, cyber stalking. Any person who by means of a public electronic communications network persistently sends a message or other matter that is grossly offensive or of an indecent, obscene, or menacing character, or causes any such message or matter to be so sent, or B, he knows to be false, for the purpose of causing annoyance, inconvenience, or needless anxiety to another, or causes such a message to be sent.
So what happens to the
Commissioner.
satirist and the comic? I mean, I don't know if anyone who watches Jonathan Pie, but he is one of my favorite British political commentators, but he does it in a satirical way. If you go on YouTube and watch Jonathan Pie, if you're not overly sensitive to profanities, but he explains the rise of people like Donald Trump in a way that may appear comic, but it could easily, so what happens to that kind of speech within society? And I'm very conscious also too of the bill that was passed recently in Scotland that is now receiving a lot of criticism. So that, as the Leader of the Opposition is indicating, how wide, because using the language outside of the context of a computer-assisted device is not a crime. But using it over the internet becomes a crime. And that is one of the difficult questions that we have to answer in putting this forward, because yes, this is a whole comprehensive regime under the Budapest Convention, but is it that the criminal act is now being perpetuated with the use of the computer device, or is it because it is used by a computer device, it now becomes a criminal act? And I think we need to be very clear with the distinction between the two, because if I can annoy somebody and embarrass them and humiliate them without the use of a computer, and I can do it lawfully, why doing it by means of a computer makes it unlawful?
because the computer is instant and wide dissemination.
And you and I
You
know.
can send it to China. What I wanted to ask, Sir David, without interrupting you, Senator, who is enforcing this? Which country is now enforcing this legislation?
But all 69 countries
Yeah, but
in the world.
is there any country in which people have been charged, repeated, or
Charged.
the courts are filled with these kinds of cases?
I saw one recently where somebody was charged in Guyana and got off.
Guyana?
Yeah, and got off. Not necessarily this section, but under their legislation.
It would be interesting for us to
That's
find out
correct.
if
In Guyana, they have cases.
they have cases in Guyana.
Under the, yeah.
Okay.
But we are all familiar as Barbadian men, with the scenario where a man has become careless in the management of his amorous relationships. And he strikes up a relationship with a woman, not his wife. And that third party then gets on the phone, 6, 9 months later on, and calls up the wife. You think you got the ring? I got Emmanuel. All of that. If you're using that and you're doing it repeatedly and tormenting the poor woman, that happens in Barbados. We know that. Heard of those things. you feel that that should be allowed? That we should turn a blind eye to it?
Even though it is true,
So David,
even though it may be true.
So David, that's not the point. I always, I don't want to delay proceedings, but we have a difference in society. When my grandmother died, my father's mother, the year I got married, I was sitting in the church. This is being recorded, right? Like I said. And my uncle was giving a eulogy. I was making the point that my aunt was born to another woman out of wedlock. And my grandmother went to the house a couple of weeks later and asked for George's child. I wouldn't tell you what my wife said to me. Should have happened to my grandfather. Different thinking, different society. And you're right.
We are streaming as well.
Yeah. I'm not speaking about me though, but I'm just saying that we live in a different society and in a different era. And yes, this thing goes all over the world, but shouldn't your appreciation or your own subjective acceptance of criticism, whether it be satire, humor, or what's not, I mean, could we perform a modern day Shakespeare play to contemporary circumstances using this legislation? Some of the things that Shakespeare would have said about people, certainly that we found humorous, as students would know to what extent is the artist protected from that. I mean, if it's put on the internet, it's a crime, but if it's done publicly, it's not.
Yeah, sorry. You would have to look at a particular section where it may say, if you do something with intent. There are sections that say that. And I read something from the convention itself, which specified that. It depends on the purpose for which you disseminate the material.
And the other operative word is cyber.
Abuse
of cyberspace.
Yeah.
So David, you were speaking of criticisms. One of the criticisms is that, yes, by an individual, was that, yes, okay, the bill seeks to follow the Budapest Convention, but that convention now is outdated in some ways.
Not true.
No, I just want to state it for the record, your opinion.
Okay.
And that, as we know, because we haven't mentioned it yet, the United Nations is, as we speak, looking at having a convention on cybercrime, of which I know for a fact that some Caribbean countries, Ghana, Jamaica, have participated in vigorously, not Barbados as much, and they're hoping to finalize crafting that convention and bring it to the General Assembly, I believe, by October. So what's your answer on that criticism of our legislation, proposed legislation, that, you know, by following the Budapest Convention, it has outlived its time?
That was Harper. And I think the minister, Ms. Cattle, in the other place, dealt effectively with his criticisms. And I won't want to repeat anything she said then. I think I saw it on television one night and I was amazed that this is the same man who 5 years ago was calling for Barbados to update its computer misuse legislation. And when you do that with this legislation, he criticizes it, he says that this is out of date. I don't know about that at all. Our legislation is in harmony with the convention. That's all I can tell you. I haven't seen what the UN is doing, of course. I know that they're working on something, but this is the one that is enforced now. And there are great benefits, of course, once we accede to that. And the process of accession is very, very simple. It was explained to us at a special meeting that the council had with the Attorney General, the Minister of Foreign Affairs and a gentleman from his ministry, setting out the steps. And there are about 6 simple things on one page can be done. In addition to that, one of the advantages of acceding to this convention is that as soon, in fact, you don't even have to wait, but it's better. As soon as you sign on, the police in Barbados have access to all the countries which are party to the convention for the purpose of sharing information about cyber criminals. Very, very important. Very important from the point of view of international cooperation.
So David, through you, Chair to Sir David, I was following the debate on the United Nations Convention because when this first came up to our attention for Parliament, I was not aware personally that it was the Budapest Convention that the legislation was based on.
Yeah.
So I was immediately following and attracted to a number of the discussion points surrounding the debate at the United Nations. Indeed, the United Nations Convention purports to go even further than this convention has gone. And the criticisms that are surrounding that seem to be more trenchant, that it is a further incursion into the rights. But then there are also, on the other hand, lots of justifications as to why the Budapest Convention has been circumvented by cyber criminals because of, obviously, once you set the
When they have
infrastructure in
they have to
place,
do a protocol.
yeah, so that you can't move fast enough, and the amount of money in cybercrime that is generated is billions of dollars, and more than the GDP of Barbados. So people traffic in this kind of thing. So my question is, we would have to, if we accede to a United Nations Convention, have to come back and revisit.
Depends when that convention
is
will come
passed.
into force.
Yeah.
You have one now in Budapest that I think 69 countries have signed on to. And this one, as soon as we pass this legislation with any amendments, doesn't matter, that will enable us to accede to that convention and get the benefits of the convention. While they're going, I don't think the one in the UN is going to be finished in a hurry. You know how it is with conventions and parties quibbling over words and all that. It'll take years. But with cybercrime as it is, no such a threat. We may get through in 3 years, I don't know. But I don't think we should wait. Barbados can't afford to wait because the Act of 2005 is no use anymore. We need to update it. This is the update.
So David, just for the records, I wanted to read in, because you read the Guyana legislation on offenses by body corporates. I wanted to read into the records the Jamaica section 14.
Okay.
For the avoidance of doubt, where body corporate commits an offense under this act, the body corporate shall be liable to the fine applicable in respect of the offense. And subsect 2, where body corporate commits an offense under this act and the court is satisfied that a director, manager, secretary, or other similar officer of that body corporate connived in the commission of the offense, that director, manager, secretary, or other similar officer shall also be liable to be proceeded against for the offense and punished accordingly. Or if they fail to exercise due diligence, same words as in the Guyana, to prevent the commission of the offense, that director, manager, secretary, or other officer shall be liable, and on conviction, fine, imprisonment. And so, similar
Well,
as well.
we've agreed that we'll ask the
The chief
administrator
to look into that, yeah.
Sir, I'd like to finish on a response to the terms of reference which you circulated to me. And I go through them one by one. In respect of paragraph 1, not only does the Law Reform Commission answer this term of reference in the affirmative, but so does the Council of Europe. The council has worked closely, perhaps. Have you got it, sir?
Yeah, it does.
You got it? Okay, good.
Got it? What we got it?
No, I have it in my,
Here.
okay, good. I have it in my folder here. Thank you. Perhaps I should redetermine and then give the answer. Just revert to one thing. To inquire into and determine whether the cybercrime bill as drafted fulfills the express purposes to ensure compliance with the International Convention, global standards and best practices to counter cybercrime and to ensure international cooperation in the combating of crime. Our answer to that is yes. Not only were we answering it in the affirmative, but the Council of Europe worked closely with the Law Reform Commission in drafting the bills. And I spoke about the 3-day seminar that they sponsored last September and how they have proclaimed that our legislation is the best contemporary legislation in this region. Secondly, to examine whether the bill as drafted curtails citizens' fundamental rights to freedom of expression as against the protection of the reputation, rights, and freedoms of other persons or their private lives. The answer to that is no, the bill does not curtail citizens' fundamental rights. It enhances the protection of reputations as envisaged in the Constitution, that part that I read out in section 12 subsection 2, as exists in the Defamation Act, Cap 199. Thirdly, to examine whether the bill as drafted provides the necessary checks and balances, safeguards and independent oversight to protect citizens' human rights, liberties, and privacy rights from potential abuses, including from expansive law enforcement powers, in order to prevent miscarriage of justice. I do not, under term of reference 3, the bill does not safeguard or provide independent oversight to protect human rights. That's not the function of the bill. It's not providing independent oversight. That's the function of various independent human rights NGOs. They're the ones, they're the watchdogs. The bill doesn't do that. 4, to examine whether the bill as drafted provides adequate protection to all of the specific categories of persons who may potentially be vulnerable to cybercrime. As far as we can see, it does provide adequate protection for the various categories of persons to whom the various clauses are directed. 5, to examine whether any of the provisions of the bill as drafted are vague, overly broad, arbitrary, and or subjective and uncertain in its imposition of liability. The members of the committee have raised 1 or 2 matters which are to be referred back to Chief Parliamentary Counsel for their further review, but generally, I think for the reasons which I advanced in my presentation, and having regard to similar legislation elsewhere, I cannot agree with the implication in term of reference number 5. 6, whether the penalties imposed by the bill are disproportionate and unreasonable in any way. Now, this is one for the committee. I did the matrix, the kind of table, and read out many of them into the record. I will also send that analysis that we did when we fashioned the penalties. And you will see, as I was able to show, that many of our penalties are in harmony with Guyana. And in 1 or 2, we are higher than they are, and in other cases, they are higher than we are. But that is a matter for the committee. I explained at the outset, the function of the Law Reform Commission is to draft the legislation and submit it, not to implement it. Not to implement it as is. If the government feels We can't live with this recommendation of the commission. The government is free to change it, because our function is only recommendatory, not implementing. And whistleblower, this doesn't apply because I think government has separate whistleblower legislation that came last year. 8, to consider whether the bill could impede innovation in the technology sector and discourage investment and research in digital infrastructure. That one I can't answer. I don't think our commission can answer. That is something for the people who are engaged in technology connected to cybercrime and cybersecurity to answer. Well, I don't think we can answer. I can't, certainly. Now, the mutual legal assistance in criminal matters amendment bill. Since the 90s, the middle 90s, we had mutual assistance in criminal matters legislation. And by treaty arrangement with America, we also signed on to mutual legal assistance treaties with America. And that MLAT was signed when I was Attorney General, sometime in the late 90s, 98 or 99. But this little amendment to the existing legislation, which as I said goes back to the middle 90s to the middle 90s, that, as you would expect, a lot of that may now be outdated. And certainly it was very limited as to the role of the central authority. We have tried in this legislation to better provide for an exchange of information between central authorities here and overseas. And whereas the previous legislation had a lacuna that left out countries except they were in the Commonwealth, we have now said the bill applies to all countries. So we cured that gap that there was. And those, sir, are my remarks and submissions. Thank you very much.
So David, just wanted to raise 2 or 3 other issues. There has been criticism that I've seen that sections of the bill, I think where they speak about the police now, police involvement, law enforcement, constitute overreach. That a policeman, and you gave a couple of Barbadian instances where all members of, politicians constituting this committee, and know what happens sometimes, that a policeman, let's say, might have a woman, you use woman case, and another man might like the woman too, and he might want to trump up something on the man. Because our legislation, unlike, I think, Guyana's or Jamaica, doesn't speak towards only gazetted officers being able to get search warrants, for instance. It speaks to any police officer being able to go get a search warrant, swearing on oath before a judicial officer, and go in and search computer, cell phone, etc. Is this a valid criticism that maybe the bill should speak towards only gazetted officers having such power?
That was one that I'm glad you raised that, because that's the difference between section 23.1 and 23.3.3. For example, 23.1 says where a judge or magistrate is satisfied on information on oath. 23.1. Give up a police officer that there are reasonable grounds for suspecting that an offense has been, is being, or is about to be committed in any public, in any place, and that there is evidence that such an offense has been, is being, or is about to be committed in that place, the magistrate may issue a warrant authorizing any police officer to enter and search that place. I think that should be the judge or magistrate. Judge or magistrate.
And that point was picked up. In fact, I raised that issue with the Attorney General.
Yeah.
When it was about to go to the Senate, and he took that point,
Yeah,
said that the Senate would make the change, but then, of course, it was referred to us. So, yeah, it would have to be magistrate or judge. Right, we agree that. But in terms of the police officer now, do you think it should only be a police officer of higher rank?
That's why I drew attention to 23.
Yeah.
Because we talked there about our other gazetted officer. You see those words in bold. And I am recommending that we standardize them. Put that in 23-1.
Yeah.
Gazetted officer, police officer. There was a feeling that gazetted officer is above the rank of inspector, I think, inspector now. But it would trouble someone at that level with the 23-1 offense. And on the other hand, I don't think there are going to be that many that this will become a burden for the police service. And I would prefer myself to see 23-1 and 23-3, similarly, gazetted officer.
Yeah. Okay. And then section 11. I would invite you, Sir David.
Section 11.
Yeah, to look at section 11, disclosure of access code. And I am wondering if section 11.2 really and truly is sufficient enough that section 11.1 can be eliminated.
Yeah, two incorporates one. So therefore you could delete one.
Yeah.
And just leave subsection
Yeah,
2.
that's my view.
I think
The
so.
only thing, the penalties, the
Yeah,
penalty in 2 is a lot more than the penalty in 1.
Yeah, but those could be changed. I understand the function of this committee is to make recommendations for
Yeah.
parts of the bill that may want a little tightening.
Yeah. Okay. And just to Ms. Drake's, one of the definition of terrorism in cyber terrorism, section 21, just wanted to make sure that it is coincidental with the definition of terrorism in our Anti-Terrorism Act, chapter 158.
That's correct. Subsection 2 provides, for the purposes of this section, terrorism has the meaning assigned to it in section 3 of the Anti-Terrorism Act, cap 158.
Just for that to be read into the records. Okay. Do any other members have any other comments to raise? If not, Sir David, we have had a full 3 hours almost with you. We thank you tremendously for your effort, your time, your thoroughness in coming before us and giving your views. And I know you would raise the question on whether you may have to come back. If any other points by any other persons who may come before us and submit need to be addressed. And I know you will be open to that possibility if required. But otherwise, we thank you, sir. I believe we will have some drink, some food. We'll have some light refreshments in a room that you would have been familiar with for almost 30 years.
No, only 25, sir.
25, including your Senate? Including your 2 years, no, yeah, because you were in the Senate 6 years.
No.
81, 85?
No. I was here 81.
You were in the Senate 81, 85.
85.
Right, 4 years.
4 years.
4 years, yeah. So that's why I thought it was almost 30 you were around here. So we'll invite you into that room for some light refreshments.
That's
Yeah.
very kind, thank you all.
Okay.
So, Mr. Chair, are we finishing now, or are we breaking and join Sir David?
Yes, I think we should. 3 hours is a long time.
Yeah. Any other business, I would only wish to say when next we would meet. We only have 2 submissions so far. We would certainly want to hear Mr. Neil Harper by Zoom because he's overseas, and to set that date. Honorable Leader of the Opposition, you're good for us to set a date.
Your answer.
Yeah.
We will have to set that date in conjunction with him.
Sorry?
We will have to set that date in conjunction with him. Or you
I think we're gonna set it. We're gonna set it.
Should we not try to meet with him and the other gentleman on the same day? Or,
Well, the question would be whether, have you looked at Mr. Williams' one?
yeah, I read both.
And you think we should have Mr. Williams as well?
Yeah, I mean,
Okay, all right. The date, I don't know, next week is a short week, of course. Parliament is resuming tomorrow, so presumably would resume on Tuesday, so that will be out. I believe the Senate will resume next week, Wednesday. Sorry?
Holiday.
Next week is a holiday too, and 2 bank holidays, so Wednesday out anyway. So I was thinking of Monday, 2 weeks from now, Monday, May the 6th, which will give Mr. Harper and whoever else, because submissions close on Friday, the 26th, so that's why we have to get this letter out, Mr. Eastman, today. And, whoever else we may decide to come, see Monday the 6th, 2 o'clock. Good date. Mr. Thorne? Leader?
Yes. I think
Opposition?
I have to with the CRC. That's not on the 6th, is it?
those dates.
Oh. They gave us? Gail Atkins. Yeah, she suggested 2 dates. May 6th is on one. All right, we go with it, sir. We go to church.
Okay, so we're adjourned until Monday, May 6th at 2 p.m.
Mr. Chair, just before we adjourn, I think Senator Watson had written
Oh, yeah.
in relation to the press release that we had, and had indicated that we should allow, especially for persons who live in the diaspora, to appear in person using the Zoom platform. So that's something that we had not taken a decision on when we first met. So we just want the committee to okay that.
Yeah.
As-
Agreed, but how now would we give notice to? I mean, that will be another publication in newspaper inviting persons who live overseas to so do.
We may just have to put an additional note in. And then she'd also indicated that we should widen the media where we publicize when the committee next meet. Because we had said we were only going to put it on Parliament's website. But she's saying that we should put any print media as well when the dates that the committee will meet.
Chair, I read the email from Senator Watson, and I have no objection to that. I mean, the widest possible viewing by the public of these deliberations is what is the objective. So I would like to propose that we adopt that as as our modus?
So those two suggestions, proposals by Senator Watson, for the record, is what leader of the opposition business in the Senate, correct? Yeah, to be agreed on. So that means, therefore, notice in the paper to that effect, both the nation and Barbados today. And where else? Y'all put this on news media as well? CBC?
We use GIS.
Yeah,
and then
GIS,
will
right, so you'll
disseminate.
inform GIS as well to publicize. Okay? So if no more business, we adjourn. Monday, May 6th, 2 o'clock. So? Yeah. So I entertain a motion to adjourn until Senator Nichols, Senator Walters. Thank you.